Parliament has requested a 6-month extension of the Electoral Act Amendment deadline, and this will allow it to finalise a law that would allow independent candidates to stand as MPs and MPLs in the national and provincial elections.
Yeah, it's been a long time coming, this. In June 2020, the Constitutional Court ruled that the Electoral Act, Act 73 of 1998, was unconstitutional because it barred independent candidates from taking part in national elections.
Well, Parliament further says, though, given the significance of the bill and the required public participation process, it won't be able to meet the June deadline.
The presiding officers of Parliament have filed papers with the Constitutional Court requesting a 6-month extension of the deadline for the finalization of the amendment to the Electoral Act. Given the significance of the bill and the required public participation process, it has since become apparent that Parliament will not be in a position to pass an amendment to the Electoral Act before the June deadline. The bill was only introduced to the National Assembly on the 10th of January this year, leaving Parliament with only 5 months to process a bill of such public significance and interest. Accordingly, the presiding officers of Parliament have approached the Apex Court to seek an extension in order to enable Parliament to properly deliberate on the bill before it and to ensure that citizens across the country are afforded an opportunity to meaningfully participate and share their views on the Electoral Amendment Bill. The bill is amending the electoral system, and therefore its enactment involves complex policy issues which impact on all adult citizens. A number of other laws as well may need to be amended as a consequence of the amendment to the Electoral Act. Parliament has undertaken numerous actions to facilitate the process since the court's judgment, and these include meetings with the Electoral Commission of South Africa, the minister, committees, as well as interested stakeholders.